a second wife who was married on top of another wife was allowed to inherit. Very many questions are coming. Married wives are mad. The concubines are celebrating. The men have been cornered. The court is looking at those men who lie to women that they have divorced. What is the recourse of this woman who has been told, I'm single, Omari, I'm not married. Vivian, come I marry you. Vivian comes and knows she's married. She does 20, 30 donkey work with you. Then when you are dead, she's being told she's not a wife. Such women, the scales of justice must now support them. You cannot marry a second wife if your marriage is monogamous. But this is succession. It is not about marriage. If this man had a wife, whether that wife is illegal, whether that marriage was not whether that marriage was a non-starter, for the purpose of succession, she becomes a wife. Not when you are alive. She will become a wife for the purpose of succession, and her children will be dependents for the purpose of succession, and she will also inherit for the purpose of succession. For ladies, do not abandon your man at the sunset years when he needs you very well. He will marry another woman. Welcome to Court Helicopter Explainer, which is double plus today with the trending explainers. This is because the High Court yesterday gave a serious judgment in a succession matter where a second wife who was married on top of another wife was allowed to inherit. Very many questions are coming. All media houses are discussing this thing. Married wives are mad. Second wives are the concubines are celebrating. The men have been cornered. What is the issue? I don't want to spoil the broth by a lot of sugar. Vivian went and looked for a succession cause number E600 of 2022 in the matter of the estate of the late Ndolo Kiyoko Musimi. The petitioners are Philippa Wanza Kiyoko, Daniel Musimi Kiyoko, and Wanza Kiyoko versus Jane Jerry Kiyoko. I want to read the whole judgment so that every Kenyan knows it. Paragraph 1. The deceased here in Ndolo Kiyoko Musimi died on 30th December 2021, and the petitioners applied for letters of administration on grounds that they were their children. Paragraph 2. Prior to his death, he had married the applicant's mother. The first wife was called Lois Wamboi Muigai under the Marriage Act of 1987. He later divorced her in January 2020. After he divorced the first wife, he married the second wife under the tenets of the Hehe customary law on 14th March 2015 and later contracted a civil marriage in Tanzania on 27th June 2015. He went, there were no women here. The Kenyan women had annoyed him. He had divorced, so he went to Tanzania and married from the Hehe community. The marriage with the objector resulted on 2 children being born. It is the Tanzanian's case that by the time she married the deceased, he had assured her that he had divorced the first wife. He told the Tanzanian beautiful lady, mimi nishaachana na bibi wa kwanza and have divorced. She testified and called 2 witnesses, being the applicant's mother. It is her case that she met the deceased sometimes in 1998 and became friends, and later proposed to her, and they moved in as husband and wife in the year 2002. By then, he informed the lady that he had divorced his wife. The deceased later visited her parents and fulfilled the traditions of dowry payments under the Hehe culture of Tanzania. And indeed, the same was paid out. Subsequently, they did a civil marriage. What did the judge do? From paragraph 26, I'll read in verbatim what the judge said. The court has heard the parties, perused the pleadings, as well as read the submissions. Paragraph 27. There is no doubt that the marriage between the objector and the deceased was illegal by virtue of the fact that his marriage with DW1 was still subsisting. The same was monogamous, and what the deceased did could easily pass as bigamy. The judge is agreeing. He had no capacity to marry. That was bigamy. Paragraph 28. There is sufficient evidence that customary marriage ceremony was conducted in Tanzania and dowry paid. Thereafter, a civil marriage was conducted, and there is a certificate to that effect. Paragraph 29. The deceased and the objector stayed together as husband and wife, and out of their union, they were blessed with 2 children or issues. Paragraph 30. Sufficient evidence showed that they conducted themselves as husband and wife, and even at his deathbed was the objector. The judge is saying, yes, dowry was paid, a civil marriage was done, they lived like husband and wife. During the man's death at the bed, that woman was the one who was at the deathbed, the Gashungwa lady. The objector testified that the deceased had told her that his first marriage had been dissolved by way of a divorce, but it was not the case, though it came much later. So she says, I was told he divorced his first wife. Paragraph 32. The totality and summary of the evidence so presented before court was that the deceased treated the objector as his wife fully. What does the law say? This is now the law. Section 3(5) of the law of succession says, notwithstanding the provisions of any other written law, despite there being a law that you cannot marry a second wife if you have a first wife and you have done a Christian marriage, the law says, despite, in spite of, a woman married under a system of law which permits polygamy is where her husband has contracted a previous or subsequent monogamous marriage to another woman. Nevertheless, a wife for the purpose of this act, and in particular, section 29 and 40 thereof, and her children are accordingly children within the meaning of this act. That is the law. How did the judge interpret it? The judge says in paragraph 35, my understanding as the judge of the above provision is that the court will validate for purposes of succession a marriage which was monogamous, and thereafter the deceased underwent another customary marriage. The act indicates notwithstanding the provisions of any other written law. Paragraph 36. In this case, the deceased indeed underwent a customary marriage ceremony and later validated it through a civil union. My position, not Omari, the judge, is that the same to the extent that the first marriage was still subsisting was null and void, legally speaking. The judge is saying, legally speaking, it was void and illegal. Paragraph 37. Do the provisions of section 3.5 above aid the objector? My answer is yes. I say so because Parliament, for purposes of succession, insulated any kind of marriage the deceased went through while he was still alive. If the said Parliament intended otherwise, then it ought to have come out clearly by spelling out, just like in the Marriage Act, that once a party undergoes a monogamous marriage, then he is barred even in his grief from undergoing another marriage. The judge is saying, Parliament allowed, notwithstanding. Why didn't the Parliament say expressly, you can't? Paragraph 38. Paragraph 39. In the case at hand, he underwent both. My reasoning, therefore, is that since the Act declared a customary marriage to be valid, despite the existence of a monogamous marriage being alive, then by the same breath, any second monogamous marriage, like the case at hand, will be deemed valid for the purpose of Succession Act, and in particular, Section 29 and 40. Consequently, I do find the objection herein plausible. The deceased, in any case, had introduced the objector to all and sundry as his wife and had children with him. Paragraph 41. The deceased's first wife, in her testimony, confirmed that she was aware that the deceased had married the objector. Paragraph 42. In my view, therefore, the area which will be contentious shall be the distribution of the estate. According to DW1, the properties in question were matrimonial, and it was unfortunate the deceased died before the originating summons, number 75 of 2019, was heard. I think this is an issue for determination at the right time. Otherwise, the objector, together with her children, for purposes of Section 3.5 and 229 of the Act, is a wife. In the premises, I shall allow the objection proceedings as follows. A. The objector Jane Jerry Kiyoko is a wife to the deceased and is hereby appointed as one of the joint administrators of the estate. 2. The administrators jointly and severally shall within 45 days from the date herein apply to have the grant confirmed. This case, people are confused and are mad with the judge. Let me put it very clear what happened. The deceased man married a woman called, this woman is called Lois Wamboi Muigai, in November 1987. He divorced her in 2020. He married in 1987 and divorced her in 2020. He purported to marry another woman in 2015. So the question that is there, was he having capacity to marry this woman in 2015? No. He had no legal capacity to marry that woman. Therefore, there was no marriage. That certificate was null and void. It was an illegal marriage, unknown to law. But the judge went further and looked deeper into the conduct of the deceased person and identified 6 things that made him declare this woman, 1, a married woman. One, he paid dowry. That's number one. Number two, he lived with her and projected himself as a husband to this woman. Three, they got 2 children out of this funny marriage. Fourth, the wife who was divorced in 2020 was aware of the existence of this Gashungwa woman. She confessed she was aware. She never took any action. Fifth, this Muzee, when he was dying in the hospital, he was in the company of this woman who the law does not know. So the judge, being confronted with these facts and the dowry being paid, the judge went into section 3. The judge went into section 3(5) of the Law of Succession Act and said, notwithstanding the provisions of any other written law, the other written law is the Marriage Act, Cap 214, which says a Christian marriage is monogamous. But the Law of Succession says you can, despite that law being there, you can get your remedies. Out of this section 315, the judge went further and said, is this not the common practice we are seeing all over? This Tanzanian woman was told by this man severally, I divorced my wife. I divorced my wife. I'm single. The woman believed. So therefore, the principle of estoppel will apply, that you cannot run away from the position that you have made the other partner or the other woman believe that you are not married. Lastly, the judge was very categorical. He never declared this woman a wife for the purpose of marriage. He declared this woman a wife for the purpose of succession, so that her and her small minors can inherit from the property of their father. The judge went to section 29 and section 40 of the Law of Succession to protect this woman. And this is, to me, a landmark ruling, a landmark judgment for the liberation of women who have always been cheated that I'm single, yet the man is married. The woman leaves, the Gen Z woman leaves her Gen Z boyfriend because she thinks she has gotten her best half, only later to be told he was married in the village. That is what the court said. On the question of the property, the judge was very clear in paragraph 42. He says, in my view, therefore, the area which will be contentious shall be the distribution of the estate. That is where it is going to be hell. What are lessons for our Kenyan women and what are lessons for our Kenyan men? One, for ladies, do not abandon your man at the sunset years when he needs you very well. He will marry another woman. Two, do not neglect the man when he has become useless. He has no money, he's medically challenged, he's a sickling, he will marry another woman. Third, whether he is married, with you, the court is looking at those men who lie to women that they have divorced. What is the recourse of this woman who has been told, I'm single, Omari, I'm not married. Vivian, come I marry you. Vivian comes and knows she's married. She does 20, 30 donkey work with you. Then when you are dead, she's being told she's not a wife. The court has gone into expanding the jurisprudence that such women, the scales of justice must now support them. They cannot walk empty-handed. They cannot be told, kwaheri, you are a stranger who overstayed. These children she has given birth, atachukua wapi? So the law justice Kimitei has expanded the law and used the word properly under section 3(5), notwithstanding. And he has distinguished properly. There is the Marriage Act, where capacity is of marrying. You cannot marry a second wife if your marriage is monogamous. But this is succession. It is not about marriage. That is why the judge has gone to invoke section 29 and section 40. That if this man had a wife, whether that wife is illegal, whether that marriage was not set, whether that marriage was a non-starter, for the purpose of succession, she becomes a wife. Not when you are alive. She will become a wife for the purpose of succession, and her children will be dependents for the purpose of succession, and she will also inherit for the purpose of succession. I hope now this settles the matter. In succession, it is about transmission of the property of the deceased person. The deceased person might not be a husband when alive because of legal circumstances, but he becomes a husband upon death. That wife you call is useless. That wife you call useless for the purpose of succession. She will be called a wife for the purpose of succession. The judge has expanded the territory called the jurisprudence of succession, and who is a wife and who is a child. Wakili Danstan Omari, thanking you for always looking for us to explain this matter. Thank you.